Welcome to the General Counsel panel. This is going to be an exciting high-level discussion among GCs from some of the most interesting and innovative companies in the tech world. We're very fortunate to have on this panel David Hyman from Netflix, Susanna Wright from Credit Karma, Kristen Sverchek from Lyft, Eve Saltman from GoPro, Karen Kramer from Quora, Stephen Kay from Roku, and Heidi Garfield from Shutterstock. We're going to start with brief self-introductions where the GCs will tell you a little bit about themselves and their companies, and then we're going to launch into a number of issues that are of interest to them. And we want this to be very interactive, so please don't be shy about asking questions. And then we hope that you will join us and continue the discussion after this panel for the wine and cheese reception, which will be right out there. So why don't we start actually on this end with David.
Great, thanks. Appreciate it. Well, my name is David Hyman. I head up legal and public policy for Netflix. I have been at Netflix for over 16 years. I started at Netflix as the only attorney. We now have about 300 attorneys on staff, or 300 attorneys and paraprofessionals, I should say. I've seen the company grow from really a scrappy little startup to what's now a very large international media conglomerate. And so I can give you guys a lot of perspective on what it's like working in a small company and one that's in hyper-growth mode.
Hi, I'm Susanna Wright. I'm the General Counsel at Credit Karma, and I have been at Credit Karma for almost exactly a year. I'm their first General Counsel, joined in last June. And prior to that, I led compliance at Tesla, and prior to that, I led compliance at Solar City. And so have kind of some interesting perspectives from both how you deal with hyper-growth public companies, and then also in sort of the fintech, consumer finance, hyper-growth startup pre-IPO company side as well.
Hi, I'm Kristen Sverchek, General Counsel at Lyft. I've been there about 5.5 years now. Actually a similar story to David's. I was the first attorney hired, had been the company's outside counsel for a few years before that. Company was about 30 people at the time I came on board. In that time, we've now grown and expanded across the United States. My team is about 60, and it includes both legal and compliance. The company itself has grown to several thousand employees. And so I've had a bit of a wild 5.5 years.
Hi, I'm Eve Saltman. I'm the General Counsel and Secretary at GoPro. I also lead corporate and business development. I have a team of 18 people, and we deal with many issues and opportunities globally. I also work on corporate strategy with the CEO, so a great mix of things. It's a lot of fun. GoPro has a cloud service ecosystem that includes our mobile apps, our online storage, and our world-class editing solutions, in addition to our best-selling cameras, our global brand, and its unprecedented social reach. So my team and I deal with a ton of different issues across a lot of different disciplines. As an example of our brand reach, we have about 36 million followers across all social channels. We're the #1 consumer electronics brand on Instagram and the 7th most watched brand overall on YouTube. So needless to say, there's a lot to do, and we really take our job as stewards of the GoPro brand as one of our #1 missions. So I look forward to sharing all of our best practices on those things today.
Hi, my name is Karen Kramer. I'm the General Counsel at Quora, and I've been practicing for about 20 years at the intersection of media and technology law. In fact, it's fair to say that those were each my first loves professionally. I had a pole planted firmly in each one of those fields really before they had converged. My first legal job was in-house at the Washington Post back when newspapers were first going online. I was in-house for a number of years at TiVo, and I've worked for a number of startups and also media companies of all sizes. When I joined Quora, it was about 1.5 years ago now. They had just launched in the Spanish language, the beginning of their globalization effort. And shortly after I joined, Quora started its monetization, launching it out of beta, and that is advertising. During the time that I've been there, we've built up a small but growing team. We're now 4 full-time people, 1 part-time person, and hiring more soon.
Hey, I'm Steve Kay. I'm the general counsel at Roku. How many Roku owners in the room? That's underrepresented in this crowd, but very surprising. Anyway, I'll tell you a little bit about Roku's business model, since there aren't actually as many Roku users as I expected. You know, most people know the company by its hardware products, the little players or Roku TVs now, but we are actually a platform company. We have about 21 million monthly active users around the world. Our primary valuation metric is around revenue monetization, where we do licensing and a very big and growing ad business. So we are really an ad tech company, a technology development and licensing company, a content distribution platform, and a big data company. In terms of my own background, I also sort of have spent most of my career at the intersection of media and technology. I started my career in private practice in New York at predecessor firm to what is now Hogan Lovells. I took my first in-house job as general counsel at Gemstar TV Guide, which was a pretty messy company at the time that I joined it, but I learned a lot about TV technology and patents and all kinds of antitrust and other interesting topics, as well as licensing. I then went back to private practice and continued in the media and technology sector and joined Roku about 4.5 years ago as general counsel. Really at the kind of inflection point for the company. Our growth has been tremendous in the years since. I started with 3 lawyers. I'm up to 18 now, and that's pretty reflective of kind of the growth in the scale and size of our business.
Hi, I'm Heidi Garfield. I'm the general counsel at Shutterstock. I've been at Shutterstock for about 6 years, 2 years in the role of GC, and prior to that I served in a couple of other functions, mostly supporting intellectual property issues, litigation matters, and compliance at the company. Prior to that I was an IP practitioner at a couple of law firms. Shutterstock is a leading global provider of content. Many people associate it with stock photography. Of course, it's so much more. The content includes photo, video, audio. Among other services, Shutterstock is essentially a licensing intermediary. I like to say as the lawyer, and nobody at the company agrees, that we sell a legal product. I'm sure in this room that is more appreciated than elsewhere at a tech company. But because we're a licensing intermediary, we represent dual and sometimes competing interests between content providers and content users, and recognize the tension inherent in, on both sides of that licensing marketplace. So it's perhaps not surprising that the company has somebody with an IP background as its general counsel, as those form some of the most complex issues. Of course, on our team we cover everything else that a high growth publicly traded company would need to cover, including all legal functions globally, as well as compliance issues.
I'm Mark Lemley. I'm not a general counsel. I'm a professor here at Stanford and a partner at the law firm of Jury Tongri. My role is co-moderator, and all I can think is that Ian thought that with a panel of general counsels this big, it might get rowdy and unruly, and I'm here to help keep things in line.
Well, and with that thought in mind, we will turn to the first issue that the panel wanted to talk about, which is an issue that's come up in a couple of panels today, and that's challenges to platform providers and technology companies. In the last year, we've seen both legal challenges and issues that perhaps change the perception. Karen, what are your thoughts on that?
So I would say as a platform, there are definitely concerns about the heightened public pressures and expectations of consumers that we're facing. A platform like Quora, which has a lot of user-generated content and a lot of personalization, like a lot of other platforms, including those that are on the panel today and big ones like Facebook, we really operate in the space between 2 highly regulated areas, privacy on the one hand and content regulations on the other. And what we've really seen is that there's been a tremendous increase in pressures that really started internationally and then have been, in a ripple effect way, moving across the waters and affecting us here. I think in the privacy area, we really think about GDPR and how much that really elevated the standards and the consciousness over here. It really raised the bar, but I think it also created a new level of awareness about privacy. And as a practical matter, for platforms, when it came time to implement things like user rights, we realized that it was really hard to just give user rights in a lot of cases to just Europeans and not also to other users in our user base. So that just changed people's expectations quite a bit. And I think that it's probably fair to say that all the discussion, all the notices that people got, the awareness of these new rights, probably contributed to some of the backlash that Facebook experienced recently in connection with Cambridge Analytica and the sharing of data with third parties. I think that not that long ago in the United States, there was pretty much just a collective shrug among US users about privacy rights. And so I think that whole sensibility is changing. Again, starting with regulations and just spreading from a consciousness standpoint. And on the content front, I think we're seeing something actually really quite similar. In the United States, it has been the case for a really long time that newspaper publishers and platforms enjoyed much more favorable protections compared to the European laws, kind of like the difference between privacy law used to be. Publishers of newspapers had constitutional protections against defamation. Platforms since the 1990s have just enjoyed a really wide range of protection under the Digital Millennium Copyright Act and the Communications Decency Act that basically gave a lot of wide latitude to not worry about claims arising from content that's being carried on the platform. Well, I think what we're seeing is that there's, in Europe, where those protections were never as strong to begin with, there's new regulations and new pressures chipping away at that. We've seen, for example, again, the laws were never as good to begin with, but the bar is being raised even higher. For example, in Germany, there's the hate speech regulation that says platforms, social media platforms, have to take down hate speech within 24 hours of notice or they're liable. In the UK, where it's always been easier to sue individuals or public figures for defamation, platforms have been held liable recently in lawsuits, or in a lot of lawsuits, on behalf of public figures, essentially holding platforms very similarly liable the way newspaper publishers were, and really almost eliminating the distinctions or making them pretty narrow, the difference between a platform and a newspaper publisher. And so what does that mean over here? Well, I think we're seeing some migration of some of that. We have a president who's talking about opening up libel laws and wanting to rewrite those. We've seen a real loss of esteem of newspaper publishers and platforms culturally over here. Media's talked about as fake news, the failing New York Times. I think there's a sense that platforms have maybe lost a bit of their halo. And recently we've seen some new and pretty previously unimagined legislation seeking to hold platforms liable for the content as intermediaries. And what I'm thinking of here is the recent sex trafficking legislation. And you might wonder, why would Quora care about that? We're a pretty upstart company, a question and answer platform. We provide questions and answers about often serious topics, and people identify themselves, and it's a pretty above board kind of place. Just to give an example of the kind of thorniness that provides, one of the top rated Quora questions is just a question asking, hey, what happened to all the, where did all the traffic go once Craigslist advertising and Backdoor shut down? So these are the kind of questions that previously in the day-to-day business operations of a content platform, we wouldn't have to think about. But now we're wondering, okay, are we, if we monetize against that, are we potentially liable under the new sex trafficking liability standard?
What are others seeing in terms of the pressure on technology companies and pressures on platforms?
Well, I think that one thing that's clear is it's both the law and consumer expectations are changing. I mean, I think with the whole Me Too movement and other things other sort of public areas, areas that people are discussing publicly, companies with big brands that, previously might have held themselves out as kind of neutral publishing platforms like Roku, become not just subject to whatever the legal limitations are or whatever the legal protections are, but I think there's also expectations from business partners as well as the public that's driving the way companies now behave in terms of the, sort of move away from sort of just a very, we're a platform, we'll just, we're not responsible for what our third parties publish on the platform. That's definitely changing the conversation internally for us.
I think, from my perspective, I think there are a few words that used to be like the buzzwords in Silicon Valley that would, drive valuation or show you that you were a good company. Platform being one, algorithm being another, big data being another one. All those words now are toxic. You don't want to be a platform, right? You don't want to have algorithms. You've got to think about different ways to do that. So I think this is all reflective, this idea of platform is all reflective of a bigger shift, both legal and politically driven, which is people, as technology becomes much more ingrained in everything that we're doing, and we're seeing, continued shifts in landscape, everything from media on our side to, information, newspapers. It becomes much more critical to be able to figure out what your impact on the world is going to be and how to play within, kind of the larger geopolitical and legal landscapes that are driving. So it's just something I think is always, at the forefront of things that we're considering. And I know we'll talk a little bit more about this, especially as the tech companies operating in a global environment. These are issues that start to be in the front of our discussions on a day-to-day basis.
Yeah, and I think from the Lyft perspective, anytime you have an online platform that brings together two people in the real world, whether you have a legal argument about Communications Decency Act immunity or something like that, there's certainly like a public sentiment that that the platform should be responsible for what happens when those people are put together. So, this is something that certainly we and our direct competitors and other marketplace or gig economy companies like the Airbnbs and Sitter Cities, urban sitters of the world are facing. And it is, legal arguments are one thing, but it's also like what the business going public, what your customers expect is another.
Yeah, I would just speak, although we do not have a lot of user-generated content. Credit Karma, we have 80 million plus users and a lot of sensitive financial information about them. They share a lot with us, and a lot of that comes down to trust. And a huge part of that, one of the things we face, certainly from a legal compliance regulatory standpoint, is how do you maintain that trust? How, especially in a lot of the heightened scrutiny right now, and a lot of suspicion that has come up around a lot of tech companies. How do you continue to structure things on your site? What information are you sharing with your members so that you are able to maintain that level of trust, that people continue to want to give you information, and what value are you providing, real value are you providing for them in exchange for that? So I think that's one area we look at. Obviously, since we're operating in the financial realm, we are subject to extraordinarily heightened regulatory scrutiny. And that's always something we're mindful of. Also, with regard to our financial partners, any sort of information that they are putting out there on our sites, what sort of obligations do we have to really monitor what those financial partners themselves are putting on? What sort of diligence, what sort of responsibilities do we have? Because we want to make sure that we're providing the best possible value for our members. What is our responsibility to ensure that we're only allowing certain partners who we have vetted, who we really believe in, onto our site? And so that's something we constantly look at on a day-to-day basis.
I echo the idea of responsibility, I think, for the company, not just in terms of the obvious, which is what do we collect from our customers or users and how do we use it, but for the service that we're offering, what we're making available. Inevitably, our users or our contributors will come back to us and expect us to own that, whatever we put out there. So when it comes to fake news or how content is misused, how editorial content could be appropriated and used in a in an arguably not editorial manner, or a manner that's questionable, or things that are subject to interpretation, where laws in one country prohibit something as morally repugnant, where laws in another country accept it. And we see this, for example, with things that seem so obviously acceptable to us in the United States, like homosexuality, and we don't have that same level of tolerance in other countries. And we put content out there, and we permit people to use that content, and if they believe it's been misused, they come back to us and expect us to own it and provide the answer and provide the solution for them. So there's a lot of balancing, the delicate tension between what we are required to do under the law and what we need to do to support our customers and our contributors and make sure that they're in a safe space where they feel like they are protected.
But so is it, I think all of you to some extent operate internationally, or at least have aspirations to do so. I mean, how do you deal with that very different set of cultural attitudes? I mean, I think it's one thing to say, well, U.S. law has a different view of free speech and the First Amendment or platform liability. It's another thing to say we want to be good members of the community, but the community expectations may be completely at odds across different countries.
I mean, I'll
Sure.
address. I think that I could look at that at a couple of different tiers, right? There's some where it's governed by our license, our contract, where we say you agreed to be subject to New York law, so we're going to just call it and move on. It gets a little trickier with laws in different countries governing IP protections and the scope of IP protections, moral rights, for example, or rights where New York law might differ and somebody hasn't consented to license us their content. In fact, somebody took their content and licensed it to us and said that they were authorized to do so. Now, we know that our contributor in that instance violated the license, but the owner of the IP still expects us to be liable. In that one, we would inevitably have to respect and consider the law of the country where that content owner resides. The moral issues or the community standards are incredibly tricky. I could not and would not purport to give an answer on how you address that in every instance. I will say that being a responsible global citizen, the last thing we would want to do is create risk for somebody because we maintain that something is lawful in the state of New York or in the United States where it might be unlawful. And I'll use homosexuality as an example, which is one I've confronted. We would never want, if content were used in a way that implied the subject of that content was engaged in something that was unlawful in the place where the content was used, that individual who appeared in the content could be himself subject to any number of horrific crimes, from legal violations to something much worse. And in a situation like that, we would, of course, wear our global citizen hat and try to do the right thing by that person.
A related issue in dealing with globalization, which David touched on a little bit, has to do with the challenges of operating global companies in a world that has become increasingly populist and more segmented. David, do you want to elaborate a little bit on those issues?
Sure. I think at least my perception is, around the globe we are seeing much more trend toward populism or nationalism, and companies that are operating on a global, in a global environment need to be much more aware of that. And to your point about being a good global citizen, I think it's almost not even being a global citizen as much as being also aware locally of how your services or offerings are going to be interpreted. And that's a tough thing to do because you end up balancing, different perspectives that raise issues both, from the PR side and the brand side of the house, to the legal side of the house, to the employee side of the house. Even here in our own country, you can see that. I mean, we had the Georgia bathroom law issue that, went through in, Hollywood of how do we deal with this? What is our responsibility as a company to engage in these kinds of issues? And so I don't really have answers for that. I just throw that out there as that these are, ongoing issues that from a general counsel's perspective that are, incredibly multidisciplinary in the sense that there's part of it is, you wear your legal hat, part of it is where your moral hat, part of it is where you protect the brand of the company, you think about employees, you think about others. And so it's a much more difficult world, at least for me, I think, in operating these days because of all these issues pulling together.
Yeah, I think one of the things we face is just figuring out which which laws do we comply with, and then if we don't comply, what is the PR backlash, or what happens to your brand? And you have to think about, well, where do you make money? First of all, as a business, where do you make money? And so you want to focus your legal compliance in those areas because you're a for-profit business. And one of the things that we face, much more a mundane issue really is, how do you have product packaging that complies across the globe? And surprisingly, one of the things is that you have to figure out, well, you have to let your marketing team know, hey, don't put so many words on the package, because words require translation and perhaps localization. So when you're dealing with things like product packaging, it's mundane, but it's a real issue that costs your company a ton of money. And figuring out how to comply with the most jurisdictions at once on a single package, that can really save your company time and money. Another thing that we look at across the globe is product safety. And we look at the use cases that people make of our product and some of the crazy videos that go out there. And not infrequently at GoPro, we have conversations about what should we do about this piece of content? Are people going to copy this? Are there going to be copycats and then people get hurt when people do crazy stunts, with their GoPros on? And so again, you have to put your brand hat on and you have to put your global citizen hat on and figure out, does this hurt your brand? Of course, when things go viral, that's great for the brand because people get inspired and they want to buy GoPros themselves. And so, so those are the kinds of international and sort of brand citizen issues we deal with.
I think David mentioned an interesting point, like populism, nationalism. I think that, in the U.S. we're kind of going through this kind of deregulatory version of populism, and it's kind of a weird hybrid. In other countries, you're seeing much more protective kinds of legislation that's very, they don't care what people are doing in the U.S. They're going to hold you to the standard. GDPR is a perfect example. If you're going to do business in Europe, you're going to comply with these regulations regardless of what you're accustomed to. I think that for us as being kind of international is kind of the next frontier for us. We built our business in the U.S. Very strongly. But to the opportunity for streaming is a global opportunity, as Netflix has shown and others have shown. So so there's a big push to go out into other markets, and I think the product side tends to be kind of easy, right? Sort of like, well, a few tweaks to the product, you can meet the local power requirements, you can do this and that. But because we are operating a platform, we have to kind of look at more the rules around privacy and marketing and all those other things that are increasingly complex and do differ. We also try to take a regional approach where we can and try to get to kind of a level of an approach that will cover us in 80-90% of the cases if we can, and again not worry if there's if a small country may have a slight tweak that we're not able to comply with right out of the gate, we'll sort of see how it goes. I think if as a growing company, you're kind of forced to make those kinds of decisions because trying to get to 100% compliance in every market is going to be a massive challenge.
Yeah, one of the other challenges in operating internationally is there was a time, at least one thought in Silicon Valley, where you could just open up a virtual business and sell to the world. And that time may have passed. Karen, what are your thoughts?
I think that's definitely true that it's much harder now to comply than it used to be, particularly with GDPR, to operate without boots on the ground. I think before GDPR, it was pretty safe to assume that if you didn't, as long as you didn't have boots on the ground, there was a limited checklist of, pretty short checklist of things you needed to do to localize. And by localize, I mean targeting users in their language or selling products and services targeted to where they're located. And at least as far as Europe is concerned, that checklist has gotten so much longer than it used to be. Not that long ago, sometime last year, I'd given a talk called The 5 Stages of GDPR Compliance, and I compared it to the 5 stages of grief, which is to say, denial, anger, bargaining, depression, and acceptance. And no matter what size company you might be working for, if you had been targeting European users, you had to some extent go through those stages in order to continue doing business in Europe. And the kind of requirements that one needed to do before could really much be done on a fairly superficial basis. I mentioned the short checklist, the short launch, or localization list, and it usually was something like cookies, banner notice, some targeted changes to your privacy policy. These are things that could be done, fairly quickly and fairly superficially. But now, if you want to do business in Europe, and the penalties are really high potentially, in terms of 2 to 4% of your global annual revenue. Even if you don't have boots on the ground, if you want to continue doing business and localizing or targeting Europeans that way, the kinds of work you need to do is a lot less superficial than that. Things like changes to your product, like user rights and portability and new opt-outs that involve cross-functional development work with your engineering team that takes precious resources and a lot of their time. There are process requirements like that your vendor agreements need to have data transfer provisions, and these have to be auditable. You have to keeping process records at any time you change a feature or launch a new product. You have considered the impact on privacy, and you're documenting this, again, an auditable requirement. There are operational requirements where even if you don't have boots on the ground, you probably need an EU representative, or you may also even need a data privacy officer, even though you're not doing business there. So what this means is that there's just a lot more complexity involved to do business virtually, at least overseas in Europe. You need a lot more resources, and the barriers to entry are a lot higher as well.
Which of the 5 stages are we in?
I suspect for many people the answer is denial, but hopefully not here. Yeah.
I think denial had to end in December for anyone who seriously wanted to be ready. But like the stages of grief, you can go back and forth to different ones. It's not a linear process.
I think the other thing just to highlight on that is I think it's just a growing trend of other countries using or updating, sort of arcane notions of jurisdiction to reach the virtual world. And so even if you're, today in your company, you feel like, oh, well, these things like GDPR don't apply, or that the application of the local laws doesn't reach me for some reason, I think the times are changing. I mean, you see this in the tax arena. This is all what's driving the taxes. Like, how do we figure out how to reach, Google and Facebook revenues? And it's just that the systems that they put into place don't quite square up with the digital world. And so that's, to your point, I think we've all, kind of benefited from in the past that lack of reaching the jurisdictional question on multiple areas within the regulatory environment, and I think that's changing.
There's also another issue in dealing internationally, which is if you do have a presence, to what extent can you enforce your rights? And Steve, do you have some thoughts on that?
Yeah, I mean, it's an interesting challenge. I mean, I think we, having grown up in the U.S. legal system, most of us, are kind of accustomed to the due process protections, both substantive and procedural, that they taught us about in law school. And I think you go into some other countries, particularly if you start heading south from here, and you don't have to go very far, in my experience. You can find yourself in a very different world where the typical protections just aren't the norm, and you can be compliant with the law. Good legal arguments about why everything that you're doing is fine and should be right, but getting access to the courts, overcoming whether it's rules about establishing a presence and having presence in order to access the courts, or having legal standing under certain circumstances. The injunction risk outside of the U.S. I mean, in the U.S., you have injunction risk. In theory, TROs are pretty hard to get, and if you get a TRO in the U.S., it's a pretty short-term, generally a short-term remedy against, to truly preserve the status quo. We've looked at the laws in other countries and had experience there where, preliminary injunctions can be many, many years long, and you never get to the substance, and all of your good legal arguments are kind of for naught if you can't get into court or you can't get to the substance.
There's one last international issue that the panel wanted to touch on, and that has to do with preserving confidentiality, the challenges of doing that internationally, especially in a world where employees are communicating on Slack and Google Hangout and similar tools. David, what are your thoughts?
So again, going back to operating as a global company, operating in multiple time zones and trying to figure out ways in which you can facilitate communication across the teams. For Netflix, we're a relatively transparent company and we share information broadly, and it's part of kind of our cultural values, which are to set the right context for people out in the field and all across the company to make their decisions. And so it's really important and a business imperative to actually have information flow pretty seamlessly. And with technology, as we all know, there's lots of data everywhere. And it's an issue that we kind of wrestle with on an ongoing basis of how much do we enable the teams to communicate using whatever is most convenient and effective for them, versus as a legal team having control over where documents are, how long documents are preserved for, and it's a hard balance. I'd say at Netflix we've opted for enabling the teams to do what they can most effectively and trying to figure out how to manage for that. And that includes everything from people on Slack, which is this great new collaborative tool, but it persists forever, and it's I always tell people email, I used to have it as email's as casual as a conversation, but as permanent as a document. So be mindful of how you operate on that. And Slack is like the worst of all of it, because now it's like messaging. Email nowadays, it's funny because my kids will tell me they never use email. Email is so formal, Dad. It's like they only text. And so now these are the same people who are the engineers in our company who are enabled with Slack, and it's just sort of like they're texting back and forth. And so the level of either candor on the one end, which is good, but the level at which they don't even think about what they're saying on the other end is bad. And so how do you manage that? Well, we've opted to keep everything and try to figure out kind of what kind of parameters we can put around retention. And sometimes even the technology won't let you do that. That's the other thing that we're finding out. It's like sometimes you want to say, okay, we've recorded something. Well, all right, well, that's fine. It's great to record it. Let it be available for everybody across the globe for 2 weeks, and then we can get rid of it. And then they're like, okay, that sounds great. And then you go to look on the back end, and they say, well, we can deny access after 2 weeks, but it's still there. And there's nothing that we can do to architect to figure that out. And that's not a big priority for them, especially nowadays that storage is like basically infinite. And so we're trying to manage through that, and we're trying to figure out sort of the right balance. But I would say it's an ongoing issue for us.
I may have an unpopular opinion here, but it's actually one area where I found GDPR to be beneficial at the company, because it enabled us to have a conversation with employees that took it to the next level. People, on our engineering team who couldn't understand why we would ever delete anything, who didn't appreciate or particularly want to have a conversation about legal risk and liability with respect to how casual their conversations are and how long we were keeping everything. GDPR in some respects provided a cover. It actually, we all know, I think, or I'll assume some familiarity, know that GDPR didn't cover all of this, but it opened the door at the company where we could start to talk to employees about risk and retention and data and where it lives and how it lives and how it's supposed to live. That actually made it easier for us to make a lot of progress. And in the last year, we were able to put in a fairly comprehensive document retention policy that otherwise would have been, well, I know actually otherwise was impossible, because I worked on it for 3 years prior to GDPR and was unsuccessful.
What media do people use in legal departments?
Is this, I mean, are people, is it
We're-
still
we're
an
a
email
Google-
world?
We're a
Is
Google,
it
we're a
Slack?
Google-based firm. I mean, the company itself is, Google Docs focused, so we don't, the lawyers on the team still try to figure out how to work in that environment with Word, which is difficult, but we're all like on Google Docs and, work through that. And Slack is continuing to be used. We use Google Hangouts a lot, and people do record on Google Hangouts or Google Meet, whatever you call it now, the enterprise version of that.
We do the same thing. We're all Google Docs, all the Google Suite, and then also a lot of Slack. And that has been very interesting in trying to educate folks throughout the company. Please, please, please don't ask really complicated legal questions on the Slack channels. We actually have a Slack channel that says no legal advice here, thanks, where you can actually ask questions of the legal department, but not seeking legal advice. But it is a challenge. It's an
I think
ongoing
it's
challenge.
a great point, which is, I think, and going back to what you were just talking about, which is using opportunities to educate people about what they should and shouldn't say. I think people are mostly receptive to that, so it's not like the legal heavy hand coming down and saying you should do this, do that, and the other thing, but trying to describe to them, things to steer away from, the reasons this is a problem. And so when you do have opportunities like GDPR to raise people's awareness, I think that's a real positive.
Yeah, well, one thing that really helps raise awareness is if you've had litigation and people have had to be prepped for deposition, and then all of a sudden all their emails from years and years ago, they come back to them and they have to be prepped about them, and then they realize, wow, why did I send all those emails with all that stuff in there? So, I wouldn't wish that on anyone, but that is one thing that has actually helped us raise awareness, is people understanding that, once you get into litigation, anything you do, put in an email, will come back to bite you, potentially. And that, I think, goes actually to the data retention issue, is I'm seeing a change where people are keeping everything, which isn't direct, it conflicts with GDPR a bit, and so you have this, can you really comply with GDPR if you have, 5 litigation holds, right? And, what do you do, because you can't delete those things, but GDPR says you have to have a data retention policy, and so, those are really difficult cross-functional discussions to have, and you're just never going to get it 100% right, and you just have to do your very best to figure out how do you navigate these issues.
Yeah, we've done a lot of work educating the team, and certainly we think about depositions, or honestly any negative piece in the news as an opportunity to educate. Like there's always like a teeny tiny silver lining to those clouds. We're also on Google and Slack. Google Meet has been actually particularly annoying for us because of the recording live meetings feature. And
It doesn't go away.
no, it doesn't go away, and like you say, it's no one's priority to fix, right, from your team or from Google's team. What I do think is most particularly tricky, and David, I would love to actually hear about this, as a hyper-growth company, we do our work educating people, and we've got some good tenure and seniority on my team, so the folks there remember everything that's happened. But as the company itself grows and grows and grows, there's just all of these new people coming in, and we have a younger workforce, so there are folks that just haven't dealt with these issues before, and so like the process of re-education is really an ongoing one that never stops.
Yeah, yes, that is true. even for us, I mean, my legal team has gone from, in the past year, from like 150 people to 300. And so and that's indicative across the company. And so, you've got people coming in from all different environments, and it's the same kind of fast-paced growth. I think, we do a number of different things to try to educate people. We have everything from, as a company, we do a new employee college. So every, month or so, we bring, 200 people that have been hired on to talk about different things. And that's an opportunity to talk about this kind of stuff. I mean, I typically give it out in the one thing, which is, hey, if you're putting anything into Slack, email, or wherever that you don't want on the front page of the New York Times, then you should come and, talk to that person in person, to try to give them an idea. And sometimes you can use examples. I'm trying to think of some of the more recent ones that have come out where people's emails, I think it was, who is it? Was it which was it the Facebook product director who had that screaming email that got published recently? I think it was with the Facebook guy. That was a great learning experience. You just can pass that around to people, and they understand. Be careful of what you write in your emails.
So another issue that's challenging for companies like yours is how to communicate to regulators about new and interesting issues like machine learning, AI, new business models that they may not understand. Susanna, what are your thoughts on that?
Sure, this is something, obviously, we try to, well, I certainly very much abide by the philosophy of it's much better to engage early on with the regulators rather than try and hide and avoid attracting their attention. I think there have been different philosophical views out in Silicon Valley for a while on that front, but typically what I found, and we see this a lot, especially in the concept of machine learning and AI, which is something we're very focused on, is and especially in the financial realm, getting out and trying to talk with regulators, talking with legislators, talking with others on the front end, trying to educate about who you are and what you do. We feel very fortunate that we always feel like we have a very good story to tell to regulators, because our mission as a company is to really increase transparency with regard to someone's financial standing, helping make financial progress possible for everyone. And as part of that, a big part of what we're doing is trying to provide our 80 million plus members with a lot of information, access to information that's previously been sort of in a black box for years. And also because of our business model, things that are good for our members from the consumer protection side of the world actually are fully baked into just how we operate. It is a true win-win model for us. And so therefore, going to regulators, especially say, for example, the CFPB, with whom we've had a great relationship for a long, long time, is because we feel like, hey, we can really partner. And so some approaches, and I'll use the CFPB as an example, under prior leadership, they were very, very focused on some innovative models or projects for innovation, but going and talking with them, doing research, collaborations, trying to join with them and other nonprofit groups to help educate consumers is a way of actually helping people to get to understand your company doing something that has them understand, oh, okay, this is what you're about. And so doing the same thing with other regulators both on the state and federal level is something that we found to be really effective in helping tell our story so people understand what we do and understand, say, when they're seeing news articles about other companies that are having data privacy issues or security issues or things like that, they already know us. They know that we're different. And actually, we've had situations where people have actually reached out to us for advice about oh, hey, how should we view this thing that's happening in these other companies? And it's been really productive from our standpoint. And so that's one thing I feel very strongly about is I think that there has been a fear about approaching regulators or interacting with people for a number of years here in Silicon Valley. And I think you can actually get so much out of turning that on its head and really proactively seeking people out to educate about who you are. And so that's one area I'm very focused on for our company as well.
That's really consistent with the way that we do and have done business as well. Obviously in a totally different space, but also a heavily regulated one. When I joined Lyft, we were not regulated anywhere yet. And we had the California Public Utilities Commission sort of breathing down our neck. And the company was on shaky ground because we didn't know it was going to happen. But we chose to be really proactive and sort of, although I hate this phrase, I'll say it anyway, open kimono about sharing Lyft's story with the regulator, and it led to a great result for us because we actually were able to work collaboratively toward designing regulations, and the regulations that were the output were ones that worked for us as a business versus being, something more like GDPR that is could be stifling to businesses. And so we were able to repeat that process, really across the nation. And we didn't get everything that we wanted in every case, but we did build good relationships that have benefited us in the years past. You know, if we have a compliance issue or something like that, we usually get a phone call instead of a nasty letter. And that's really, like, I think the biggest difference.
Yeah, that's a huge, that should be a huge incentive for everybody in this room. It is so much better to get a friendly phone call and be like, hey, I saw this thing. Can you help me understand it? And then you're much more likely to have a friendly conversation. And if there's an issue, figure out a productive way of addressing it rather than facing a CID or a subpoena or something else.
There are two important issues that the panel wanted to touch on where the discussion may be a little bit different today than it was a year ago. And the first of those is managing diversity and inclusion in the legal department, particularly in the Me Too era. And Eve, do you want to start off that discussion?
Sure. Well, I mean, this is definitely a very high-profile and meaty topic these days, and I think the number one best practice for us as general counsel leaders is to be proactive within our organizations and ensure that we have the right tools and policies in place to protect our employees. I mean, there's a lot of things you can do here, right? You have to have really comprehensive, understandable and accessible anti-harassment and anti-discrimination policies. And those policies should make clear that there's a zero tolerance policy for inappropriate and harassing behaviors, one. And then you want to make sure that people understand, how do I report these behaviors? And then there's a big cross-functional piece here, which is working with your people and HR team. And so you want to make sure that you're aligned with them on many best practices, which are, you know, for example, you want to make sure you have the right procedures in place to conduct investigations. And when people come to the people team, they should know that their complaints are going to get investigated promptly and thoroughly. And you need to make sure that your people team has the bandwidth to do this. So if there is, you know, if they don't have the bandwidth to do the investigations internally, make sure you have outside investigators that are available. Or for reasons of impartiality, you need to make sure you have outside investigators available. So it's all about making sure your employee population understands that you have processes, you have zero tolerance policy for these behaviors, and when they're reported, they're going to get taken seriously. There's also, you know, another best practice that a lot of companies are looking at, which is having an anonymous hotline. And you know, there are a number of solutions out there, and those are a great way for us on this panel and other leaders to understand what is going on at the company, how are people feeling, what's the pulse at the company. So that's something that we're looking into at GoPro. And I also think that there's policies, there's procedures, but there's kind of no substitute for just getting out there and talking to employees and making sure you understand what's going on. Get out there and don't wait for issues to come to your office. Get out there and get to know employees. Since I've been back at GoPro a couple of months now, I am making a practice of reaching out to various women colleagues and getting together for 30-minute chats and just checking in and see how they're doing. And it's really a great way to mitigate risk, make sure you understand what's going on at the company, and also to make sure that people know you're an open door. They can come to you and they can talk to you about their issues. And that way you can spot issues before they occur. I think there's so much more to be said about this topic. So I want to make sure everyone else gets their words in.
I'll touch on a little bit because it's an area we focus on, and I'm probably slightly different than most people here because the legal team itself is you know, large in my organization, and that has some benefits to it as well as maybe some disadvantages. But since this is best practices, I'll throw out a couple of things that we've done that you guys may think about or take. One that I think is very unique, and this is across the entire company with respect to, we have different levels of, we're a relatively flat organization title-wise. We have VPs, directors, and basically managers. But directors and above all are able to see everybody else's compensation across the company. So it's an open comp organization in that way. And it does create some swirl, but I've been a big proponent of it at that level because I think it holds people accountable to why there are differences between salaries. So to the extent you're trying to address in your company wage disparity, either on gender base or on race base, I find it to be important to keep that open, and it starts a dialogue both for the person who sees that salary and for people to be able to question within each other's organizations as to why they're structuring their compensation the way they are. So that's a unique thing we do, but I'm not sure if it fits for everybody. But I think it is important in this particular discussion. I think the other thing that we've done, both as a legal team and sort of across the company, is unconscious bias training. So with respect to, all of us have our own unconscious biases, and we bring them to work every day. And having that awareness of what your biases could be, or what your biases most likely are, and understanding how they might manifest themselves in the workplace, I think is very enlightening. We've spent a bunch of time at the company. We read as both a company and as a legal team Sheryl Sandberg's book on Lean In, which was enlightening to a lot of people across the team, and just little habits, little things that you can pick up on from those kinds of interactions, I think are helpful in the workforce. So I would encourage people to try to pursue something along the lines of unconscious bias training. And I think the last thing that I would highlight is diversity begets diversity. So in a small legal department, I think it's hard because you may have the first attorney of color and you feel like you're doing a great job, but it's pretty lonely for that first person of color to be at the company. And while you may feel like you've done a great job of diversifying at some point, it's not sustainable. People need to feel like they're in an environment that they can be themselves and they can bring themselves to work. And so I think it's important as you do that to always be thoughtful about how you can expand your circles of, your networking to try to bring more and more people into the company and expand those networks so that you actually have a very diverse candidate pool. And then from that candidate pool, to continue to sort of push the boundaries of hiring more and more diverse candidates. And you'll find there's a flywheel effect to that. And I think we've had a really we've had success in that. And that the environment then is a welcoming environment. It's a much more inclusive environment. There's this whole, what is it? It's like diversity is being invited to the prom, but, inclusion is being asked to dance, right? And so the idea is that we're trying to get people to be asked to dance. And I think those are some ways that can help that out.
I think something else I think you guys did, which we recently moved to, is equal parental leave for men and women, any caregivers. Is that something that Netflix has?
Yeah, I mean, it's, yeah. I was going to say it's equal. I've never even heard of it. But it's like,
Well,
seems odd to me that wouldn't be
a lot of companies have
just for maternity leave.
longer leaves or just just paid maternity leave. And from my perspective, it's incredibly important for companies to support equivalent leaves, no matter which caregiver you are, because otherwise it sort of places the women in an other category because they're out longer. And so you really want both sexes to be engaging in that caregiver responsibility in the same way, and have the company be promoting that. I was the first person to take maternity leave at Lyft because I was an early employee, one of the only women of childbearing age, and that was something that was important to me then, and we've progressed throughout the years. But I still think you see, even in the Silicon Valley, a lot of tech companies behind on this.
Mm-hmm. So we're running low on time, but we're going to allow for a question or two if we can. And before we get to questions, if you do want to ask questions, please come to the microphone. There's one last topic that is another one that a year ago we probably wouldn't have been talking about, and that is increased social activism by tech companies. And Heidi, do you want to say a few words about that phenomenon?
Sure. I think that the idea of the corporation as a global actor, as a political actor, is not a new one. We've heard today, and all of us have probably experienced in our careers, that we have matters of public policy that are not just interesting to our companies, but critical for our companies to survive. What has changed in the last year, 2 years, I'll call January 2017 a tipping point, was changes in, particularly in the United States, changes in requests to legal teams to step forward and put our names and our muscle, our dollars, to sign on to amicus briefs and so on, in a heightened political environment where the laws that are being advocated for or against are matters of they're matters of public policy that are critical to our organizations, but they really sound in social issues that are critical to all of us as citizens and mean a lot to our employees. So as one example, an immigration ban, put into effect, I think, a year and a half ago, or proposed thereabout, I don't remember the exact date, led to enormous outcry from a number of different people, I suppose whether you were for or against it. And the corporations were called upon to step forward and identify what that meant to our organization. So these are not political issues that the corporation doesn't care about. They're actually things that mean something to us, and we can't play Switzerland here, right? Because our employees care, our customers care. We've heard a little bit about this today in respect of other issues where whether it's our employees, our customer base, and our contributor base looking to the company and asking what we'll do and when. In my 6 years at Shutterstock, overseeing, among other things, I think a nascent public policy program, in the last 2 years, I've seen the requests for us to put our name and our dollars and our time toward political issues absolutely explode. And it's been an inspiring and exciting time, an opportunity to engage our employees and let them feel, let them know that the issues that are happening, that they're confronting in the real world are real to the company, and we're taking a stand on the things that matter to us.
I want to add that it poses special challenges for platforms, because as a platform you want to say you're carrying all views and you're a vehicle for people of all persuasions and political views to express their viewpoint. So you don't always want to be seen as taking sides, but on the other hand, when it comes to things like the immigration ban, if you have a heavy H-1B dependent visa workforce like we do, that actually is something that really cuts really close to home to business interests, and that's a reason to respond affirmatively when asked to sign on to amicus brief. And I think that we're often, during the time that I've been at Quora, there's been a ton of amicus brief sign-on requests, and I think it's been a very careful balancing of how much is this a business need that either directly affects our employees or how we do business versus a political or social issue. And
I do want to flag what seems to me a move from a kind of viewpoint that is, well, gosh, we have customers that are on both sides, and so we should stay out of anything when we can, right, to an increased focus on employees. And I think as employees, and this is in part a generational shift, it is in part a Trump shift, right, are more politically active, more politically aware, but also more interested in making sure they're working at a company that aligns in some sense with their values. I think the companies are now, it's much harder to stay neutral because that's itself a negative in some sense for a lot of employees.
I'll say I think it's, and maybe I'm repeating what I said before, but in that respect, it's a really exciting and essential way to communicate with employees and to help employees drive forward with the issues that are critical to the organization.
Well, and on that note, and because, excuse me, you are either the most polite audience that we've had in 15 years or the most enthusiastic for the wine and cheese reception that is about to start, I think at this point we'll just thank the panel for a terrific presentation and invite you to continue the discussion with them individually here and then outside for the wine and cheese. Thank you so much for coming. Thank you for the panel.